Good afternoon, everyone. My name is Jayla Paul. I'm an associate here at Bond in the IP group, and I will be presenting alongside Fred Price and Taria Jenkins, who are both members in the IP group here at Bond. Next slide, please. So today we will be talking about intellectual property. There are four types: patents, trademarks, copyrights, and trade secrets. Today's presentation will focus on trademarks and copyright. Next slide. So first, starting with trademark. A trademark or service mark is a word, name, symbol, or device, or a combination thereof. The mark is used or adopted to identify goods and or services and to distinguish them from those sold by competitors. Non-traditional trademarks may also be protected, so think of colors, for example, the pink in the Owens Corning's insulation or Tiffany blue, and sounds such as the sound of NBC chime. So under the common law, rights are created based on use of the mark in commerce in connection with particular goods and or services, where consumers will view the mark as a source indicator for these goods and services. There must be continuous and exclusive use of the exact trademark, and trademarks have unlimited life. They last for as long as the trademark is in use. So under the common law, we know that rights arise from use in commerce. And as a trademark owner, you have the right to prevent others from using a confusingly similar mark on comparable goods or services. However, federal registration is a bit different. It does not actually confer rights, but it does give you extra trademark protection. So for example, nationwide exclusivity, federal registration grants you exclusive rights to use your mark across the United States, which means your protection is nationwide. Second, you gain access to federal courts for enforcement, so you have federal court jurisdiction. Your registration will also serve as prima facie evidence of ownership, validity, exclusive rights, and continuous use. Also, it provides constructive notice of rights, which means that others are legally deemed to know your mark exists. Federal registration also provides statutory remedies, including the possibility of treble damages. Also, your mark will become incontestable after 5 years, which makes it extremely difficult for others to challenge your trademark rights. And finally, federal registration provides a basis for foreign registration. So when selecting a trademark, there are two basic requirements. One, the mark must be distinctive. In other words, it must be unique as applied to goods and or services, and it must identify the source of the goods and services and not merely be descriptive of those goods and services. Second, the mark must not be confusingly similar to an existing common law mark, applied for, or registered mark. Next, we will talk about the spectrum of trademark distinctiveness, starting from strongest to weakest. So first, we have fanciful marks. These are completely made up words with no prior meaning. For example, names like Clorox and Zira. Because these words are invented, they're considered the strongest type of trademark. Next, we have arbitrary marks. So these are real words, but they're used in a different context. For example, Apple for computers. Apple is a common fruit, but here it's used to describe something different that does not relate to the actual word. Arbitrary marks are also very strong because they do not describe the product. Next, we have suggestive marks. These marks indicate a nature, quality, or characteristic of the goods or services, but require some type of imagination to make that connection on the part of the consumer. So these examples of suggestive marks would include Blu-ray disc, chicken of the sea. Then moving down the scale, we have descriptive marks. These marks directly describe a feature or characteristic about the product. For example, dry fast glue. These marks are a bit weaker and usually need to acquire distinctiveness, also known as secondary meaning, through use before they're protected. And finally, we have generic terms. These terms designate a general type or class of product. For example, car, software. These terms can never be trademarked because they're too broad and they belong to everyone. So everyone needs to be able to use those common words. So from fanciful to generic, the strength of a trademark depends on how unique and distinctive it is. Next slide, please. And now I will turn it over to Fred Price, who will go over the proper use of a trademark.
Thanks, Jayla. So proper use of a trademark, the proper use has to pass the acid test. So not that acid test of the 60s, but a proper use of a trademark acid test, starting with A here, adjective. So you want to use your trademarks as an adjective and not as a noun. For example, buy Lego toy blocks, not buy Legos, or buy Band-Aid bandages, not buy Band-Aids. And same with Nike sneakers or shoes, not buy Nikes. Further, you don't want to use a possessive or the plural form of the mark unless the mark itself is possessive or plural. And beware of genericide. Example follow here. So as Jayla showed in the spectrum of distinctiveness, on the right-hand side was generic marks, which never can be, which are not protectable. And these marks, as you see here, used to be registered marks, but because they were used improperly as a noun, they are no longer protected because they died a slow death of genericide. Certain companies want to continue to protect their mark from genericide. So as you see here, Xerox put out a marketing piece that there's no such thing as a Xerox. In other words, it's not a noun, but it's a made-up term. It's their trademark to keep people from saying, for example, please Xerox this for me or get me a Xerox of that paper. C, for consistent and continuous use. The mark should be used the same way each time. So you see this Baldwinsville B here. At the top of the presentation, this Baldwinsville B also had a circle around it that had some wording. I think it had Baldwinsville, for example. This is the same B being used, but it's not the same mark. So the mark would have to be used with a circle around it with the wording each time if that's the mark that's registered. I, identification. So depending on whether the mark is registered or not, and whether it's a goods trademark or a service mark, here are some symbols that can be used after the trademark in the upper right-hand corner. Now, as I note here in the first bullet, there's no need to use it each time, but you want to use it at least one time, and probably the first time, to show to the public that the particular mark is being used as a mark in commerce. So the TM is for goods, and the SM is for service marks, but the TM and the SM qualify common law marks. In other words, marks that are not yet registered, whereas the circle R symbol is used for federally registered marks. And it's to alert the public that you have a federal registration on a particular mark. And if that circle R is not used, it can limit the damages you can receive for trademark infringement. And finally, D, the mark, as noted by Jayla in the beginning of this presentation, needs to be distinctive. Again, suggestive, arbitrary, or fanciful. But you also want to distinguish the mark from the surrounding text. And that can be simply done by using quotation marks or a capital letter or all caps, distinctive print, or distinctive color. You want to show the public here that you are using the word as a trademark and not as a noun. Next. So proper use. On goods, there are several ways that you can use a trademark properly. The best way to do this, if the product is large enough, is on the product itself. Next is on product packaging or the label of a product that's either on the product packaging or the product itself. And the mark can also be used on marketing materials such as hard copy marketing piece or a website, but there are certain other requirements, including the mark needs to be used next to either a description of the goods or a picture of the goods, and also provide a means for ordering the product. In other words, if it's on a website, a buy now button, or wording such as, to order the product, call this number. And for services, much easier. You just use the mark on a marketing piece, again, such as the website or hard copy marketing materials, next to a description of the services. So for trademarks, if you remember anything from my portion of the presentation, this should be it. It's highly recommended, although not required, to have a clearance search performed, and that is just searching the trademark database and also doing some Google searches to see if there are any other similar trademarks out there, because it can be very difficult once you invest a lot of money in branding for a trademark to then have to turn around if you receive a cease and desist letter from a potential competitor saying, hey, we came up with this trademark first. You need to stop now. We're going to sue you for damages. So again, it's always best to know going into this prior to having to spend money to rebrand and potential litigation damages as well. Next slide. Okay, starting on copyrights. Next. So what is a copyright? Well, first, copyright's governed exclusively by federal law. There's no common law copyright. And a copyright's defined as original work of authorship that's fixed in a tangible medium. What does that mean? Well, original means it's new to the author. The author is the human creator of the work, not AI. Tangible medium can be paper or electronic. So, and then fixed, not necessarily permanent, and it's words fixed to a page, either hard copy or electronic. Voices fixed to electronic media, or images, or software fixed to computer memory. Next. So authors and owners. So an author in the first instance is the creator of the work, unless the work is a work for hire, which is then owned by the employer of the author. So again, in the first instance, the author is considered the owner, unless in the situation of a work for hire, which is defined as the copyrighted work created or prepared by an employee for its employer in the scope of their employment. So for example, this presentation isn't owned by the attorneys you see here during this presentation, but it's owned by our law firm. And authors, like I said, are generally owners unless the author's ownership is transferred or licensed. And that has to be in writing. And copyrights can be jointly owned, but with some complexities associated therewith. So copyrightable subject matter, there's a lot here. Can be literary works, text, prose, poetry, stories, books, musical works, dramatic works, sculptural works, recorded music. So it could be the written music and musical works and the recorded music on CDs or audio tapes, LPs, etc. Videos, motion pictures, photographs, and computer programming. Also very important here, what does a copyright not cover? It doesn't cover ideas or facts, but it only protects the expression of those ideas. It doesn't cover inventions, discoveries, doesn't cover what a trademark's going to cover. Also doesn't cover works by the US government, works not in a tangible medium as noted above, and works in the public domain. Again, the categories of these works include literary works, performing arts, visual arts, motion pictures, photographs, and other digital content. These are really the broad categories of copyrightable works. Next. Importantly here, protection is automatic. Begins with creation. So as soon as your notes are fixed to a page, or the lyrics of a song are fixed to a page, or electronically on your laptop, protected, as long as it's original to you. Registration, however, is a prerequisite to filing a lawsuit. You must be registered prior to filing. And if you register within 3 months of publication, you can seek statutory damages for infringement. And you don't have to prove actual damages, which can be very, very helpful to seek these statutory damages. And you can see there's a big range of statutory damages, and that depends on how willful the infringement was. And if you can also prove the infringement was willful, you can seek up to $150,000 per work, per infringement. And you can also seek attorney's fees and costs for the proceeding. And next, Taria Jenkins will take over the remainder of the copyright program here.
Hello, everybody. So what rights are provided through copyright? A copyright owner or the holder of a copyright has the right to control the following for a particular work, which is the actual item that is copyrighted, or for copies of that work. There's what we call a bundle of rights there, and generally it's 5 to 6 rights. The right to own and control reproduction of the work, the right to prepare derivative works from the work. So you can create other copyrightable materials based on that work. The right to control distribution of the work, the right to publicly perform a work, such as a play or a movie or things of that nature. That particular performance right does not apply to sound recordings, which we'll cover down in number 6, and then the right to publicly display the work. Number 6 is for a sound recording. There is no public performance right for a sound recording, except in the case of digital audio transmission of sound recordings. So the copyright owner or the holder has the right to determine which of those rights they're going to provide to you and which of those rights they're going to reserve for their own use. Next slide. A copyright notice. Interesting thing, a copyright notice is not required under law. There's no legal requirement for it. However, if you do use a copyright notice on your works, you will prevent what is known as the innocent infringer defense, meaning that a person who inadvertently infringes your work cannot say that. It cannot use that defense because they are on notice based on your notice on the work itself or on things that sort of advertise the work. There are 3 elements to a copyright notice. First is the word itself. You can use the word copyright. You can use an abbreviation for copyright, or you can use the symbol C in a circle for your particular work. You want to indicate the year the work was first published and also the name of the owner, whether that is yourself as an individual or an organization. And so there's an example right there on the screen, copyright 2009, Joe Author. Another element that we recommend that you include with your copyright notice is the language "all rights reserves." What that does is that tells the public that I am reserving that bundle of rights that we just talked about, those 5 or 6 elements. I am reserving those, and I'm putting the world on notice that I am reserving all aspects of my rights in the copyrighted work. Next slide. So what is one of the key takeaways that I want you to have is that copyright lasts for a really long time. For an individual, for works created after January 1, 1978, the time of duration is the life of the author plus 70 years. If there is a corporate or institutional owner or work for hire, the duration is the shorter of 95 years after publication or 120 years after the creation of the work. There are other time frames for works that were created prior to 1978, and so you can find charts online with respect to those older works, or you can call us and we'll be happy to help you understand what the duration of a copyright is for particular works that you're interested in. And the key thing to keep in mind is you should always assume that there's a valid copyright in a work. And that is whether or not there's a notice on it, whether or not you know the actual point of creation, assume a valid copyright in works that are qualifying for such. For works that are in the public domain, what that means is the copyright has expired or has not been renewed. And right now, works in the public domain generally are those created before 1928. And so again, copyright lasts a really long time, so don't assume that because a work may be old, but not, necessarily before 1928, that the copyright has expired or no longer exists. Next slide. So now let's talk about some limitations and exceptions to copyright. And before I jump into that, one of the other things that I would love for you to take away from this is copyright actually will basically be in place. You don't have to have an intent to infringe a copyright. You can actually have no intent at all. Again, there are innocent infringers. There are infringers all the way on the other end of the spectrum that are willful infringers. But if you are found responsible for infringing a copyright, really the next set of issues is not whether or not it was willful. That may be factored in and considered, but it's really how much are you going to pay to the copyright holder for infringing their copyright. There are some exceptions to copyright. And the exceptions will basically require that you or will remove the requirement that you get the permission of the copyright holder or permission of the owner, and therefore you can use the works without obtaining those permissions. There are three particular exceptions or limitations that we're going to talk about today: the fair use exception to copyright, the face-to-face or in-classroom instruction exception for educators, and then also the online instruction exemption, which is under the TEACH Act, which stands for Technology, Education, and Copyright Harmonization Act. And those exceptions are right there in the copyright statute in case you're interested in that. Next slide. So let's talk about fair use. There is sort of an assumption, and in some cases a misconception, that if I am using works for educational purposes, that I have a blanket fair use exception to copyright law. And unfortunately, that is not true. So copyright law does seek to provide educators with a little bit of latitude or some latitude in the use of copyrighted works. Those are needed when you are educating individuals. You really do need to use specific works in order to really bring education alive and make the education effective. And so fair use doctrine will permit use of a copyrighted work without permission of author, as long as the use is considered fair. This particular exception covers education, including scholarship, including research, teaching, and other free speech issues such as commentary or criticism. Here's the great thing about fair use. If it applies, if the doctrine applies, there's no need for you to check any of the other exceptions. However, the test is quite nuanced for copyright, and so sometimes it's difficult to determine in advance. There is a 4-factor test, which requires quite a bit of balancing among the 4 factors. And to make things even more challenging, there is inconsistency in the judicial rulings about what constitutes fair use and what does not. Those inconsistencies can actually also be seen within a particular state or federal court system. And so it's hard to have hard and fast rules that you can apply. So you may need our help in assessing fair use. Next slide. So here's the 4-part test. First of all, we're going to measure the purpose and character of the use. If the use tends towards those items outlined in the statute, commentary, criticism, news reporting, education, research, teaching, those tend to lean towards fair use as you go through the 4 factors and you balance. What does not lean towards fair use is when you are using the particular work for commercial purposes, you're going to basically gain a benefit or financial benefit from the use of the work. That tends to lean against fair use. Second factor, the nature of the original copyrighted work. It plays a part in whether or not a court or other tribunal will make a decision on the scope of protection for a copyrighted work. So if it is highly creative and original, think of a painting, think of an image, a photograph, think of a movie or some other type of performance, those tend to have a greater scope of protection than something that is more on the factual side of the world. Remember that facts are something that copyright does not protect. So if you have a particular article and you're citing lots of factual information, the factual content may not be protected by copyright, but the work itself as a whole may be protected. Factor 3, the amount and the substance of what you are using. So another misconception in the educational world is I can use the entire copyrighted work and do whatever I want to do from those bundles of rights. I can distribute it, I can display it, I can make copies, I can do all of those things. That is not the case, even for educational use. In this instance, less is more. So you always want to lean towards using less of a copyrighted work, excerpting that work for your particular teaching purposes or learning purposes. And also you want to use other things such as time to restrict the use, perhaps restrict access and the ability to copy the work by those individuals that you are teaching. Less is more when it comes to that particular factor. And then finally, the effect upon the work's value in the marketplace. So again, if you're leaning towards, your use is leaning towards a commercial use, you are borrowing someone else's protected materials to create your own new protected material, a derivative work, that you're going to sell for profit, you are likely not going to qualify under the balancing test as a fair use. So you just want to be careful with that. The test is extraordinarily nuanced. It's highly subjective. And so you might want to check in with legal counsel if you're having particular issues or concerns in this area. It's not straightforward. Here are some copyright fair use key questions that you may want to ask, and also again that you may want to check in and collaborate with legal counsel as it relates to these issues. Is the use for commercial purposes, or is it one of those exceptions, right, within the educational or free speech areas? Why are you using the work? Are you using the work to teach? Are you using the work to build something else, a new curriculum or some other item that you're going to profit from? How much of the work are you using? How long are you using the work? Does your use of the work hurt sales of the original work? Does it have the potential to be a substitute for the original work? And are you providing credit to the author? These are key questions that we want to analyze as we determine whether or not a use will qualify for the fair use exceptions. And so a couple of points before we leave this slide. One, you may actually go through that 4-part assessment that we just talked about and determine that I really feel like I'm on the right side of this issue. I feel like my use would qualify as fair use. Your counsel may feel the same way. We may say, yes, this may well qualify as a fair use. However, there are some instances where that use may still be challenged, and you may end up having to litigate that issue. So that's something that you want to be aware of. And we are happy to collaborate with you on ways that you can sort of minimize risk in that regard. One other thing that might be a misconception, if you are providing credit to the author or an attribution to the author, that does not necessarily relieve you of infringement, okay? You can still give credit to the author, but the author you may actually require the author's permission for use of the work. Attribution is a moral right. It's a little different from copyright. We'll talk about that a little further in the presentation, but just understand that that alone will not alleviate your responsibility for infringement. Next slide. So copyright, another exception is the face-to-face or in-classroom instruction exception to fair use. This is one of the broadest exceptions to copyright in the educational setting. It must be for face-to-face instruction in classroom, and it must be for students of that particular class. There are specific requirements that relate to face-to-face instruction, but it does permit you to do broad teaching. So for example, you may be able to show an entire movie under this exception if you're live in a classroom, if it's part of your teaching that you're doing, and you will not need the permission of the rights holder for that particular use. Note that in classroom and face-to-face instruction, though, is limited in what you can do. They're limited to performance or display of the work. You may not reproduce it, you may not distribute it. And so we have to make sure that the proper controls are in place as it relates to those particular items. This exception is for live classroom instruction. Online instruction is covered by the TEACH Act. Next slide. So another set of assumptions or things that we want to keep in mind, and I know I've said this once, but permission to use a copyrighted work is almost always required unless there is a valid exception, such as fair use, the in-classroom teaching exception, or the TEACH Act. Providing the credit to the source is not a defense to copyright infringement. And there are other practical considerations that you want to take into account. Litigation can be costly, it can be time-consuming, and it can really take you away from what you're really there to do, which is to educate. And so we want to do our best to minimize risk as it relates to use of copyrighted materials in the educational setting. As Fred mentioned previously, there are statutory damages that are available to certain rights holders in cases, and that can be as much as, I think it's $150,000 per work infringed. And then there are also enhanced damages for willful infringement, okay? Injunctions. Injunctions are when a court orders you to immediately stop something. And that is a pretty intense and very challenging situation. We certainly wouldn't want any of our educational clients to be in a position where they're having to deal with and face an injunction. And then finally, bad press. Your organization does not want to be sort of the example that is set because of a use that exceeds the boundaries or the scope of proper use. And I believe that with the climate that we're currently in, the education realm is fair game, just as other settings are as well. Next slide. So the TEACH Act covers online learning, and this particular exception was created as a result of the digital environment and the need to cover issues in the online environment that may not necessarily be a challenge in the live brick and mortar setting. So it covers online instruction, both live and asynchronous learning. It is a narrow exception and it has additional requirements due to the digital environment. It is important for both the Teach Act exception as well as the in-class exception that you have lawful rights to use the work that you are performing or displaying. Again, there's a limitation in both of those settings to just performance and display. You cannot reproduce those works, you cannot distribute those works and remain under the exception. All right. The use must be under the direction of or supervision of an instructor, and that language comes right out of the statute as an integral part of a class session that is offered as a regular part of the institution's mediated instructional activities. So it needs to be in a classroom or for a class, and it also needs to be directed towards students of that class as part of your regular commercial activities. There are additional controls that are required under the Teach Act that you limit access so that your students do not get a copy of the work and end up distributing that work further. And the exception cannot be used to disseminate materials that should be purchased or licensed. In other words, if there is a content license that is needed for those materials, this exception will not alleviate that requirement. Next slide. So let's finish up just by talking a little bit about image use. There's some special considerations that we need to take into account when you're considering the use of images. Before I jump into those, another sort of key pointer, it is not a good idea to pull images off of the web. Do not pull them off of Pinterest. Do not pull them off of other social media sites. You want to be very, very careful about pulling images because there are rights that are attached to those images, and it is not unusual for the rights holders to come after individuals, including those in the educational setting. There are also what we call copyright trolls, and those people sort of make a living by posting things and then coming after you for monetary licensing of those materials after you've pulled it off of the website. There are digital trackers attached to certain images. This happens a lot on Pinterest. And so you want to be really, really careful not to pull images from a website, and just make sure that you have an appropriate either free license or license to use those images. Images involve both copyright and other moral rights. The moral rights are the rights of the photographer to even be associated with the image or not, and to require attribution. There are also rights of subjects in images. So you have to have releases both from a photographer as well as any subjects in those images. Their rights include the right to privacy. If they're in a certain setting, the classroom setting may be a setting where there's a reasonable expectation of privacy, okay? So just be careful in that regard. Also, if you're going to use that image, again, for commercial purposes, you need permission of the photographer as well as subjects in that image for those purposes. You may need to credit the photographer, but again, that is not going to alleviate you from being liable for infringement. And so be careful of that. And then you also need, again, the authorization of the subjects in the photo or their agents. So if you're taking photos of children, you want to definitely have a written, signed release on file from the parents of those children for any advertising that you're doing using those images, or for any other use that is a public use. It's the safe thing to do. And so we talked a little bit about right of privacy in places where there's a reasonable expectation of privacy, and then also the right of publicity, that you cannot use an image commercially without authorization. Next slide. So here are some other key takeaways. Again, and I may have repeated this, this is probably my third or fourth time saying this. You want to assume that there is a valid, enforceable copyright in whatever that particular work is, and determine whether or not an exception applies or if a license or purchase of rights is required. 2, you want to have a copyright policy with respect to your organization that governs the creation and use of copyrighted materials, particularly things that may be pulled from the online space and displayed online, not just in that setting, but that is a particular area of concern. You may want to work with us to create checklists or supporting materials for teachers and staff in your organization. Do not pull material from websites unless you confirm the status or confirm that there is a license in place to avoid liability claims. And then also you want to confirm authorizations for image uses from photographers and subjects of those images. Next slide. We are happy to answer any questions that you might have in this regard. We might have a few minutes here in case there are any questions in the chat. But if not, please feel free to reach out to each of us and we will be happy to assist you. And it has been great to speak to you regarding the intellectual property issues today.